So the neighbor there relaying this fear and showing that he's going to protect her because she's in this vulnerable situation. That can be powerful. Michael Jaafar and the judge did, over the objection of the state, say that it is coming in. So the state said, well, we're going to bring it in our case in chief. Who do you think should bring it out first in their opening statement, if that's allowed?
I think we've seen many. I've always given the analogy, when I'd get a bad report card as a kid, I'd call my dad when he was at his office and tell him about it because he'd had 5-6 hours to stew on it. So I've always given that analogy. The state has to bring it out. They had to file their motion objecting for the evidence to be introduced, but this is clearly should have been introduced. This is absolutely a known hearsay to the exception rule. 100% that was going to be admitted. I mean, for many, this passes at least no less than 3 exceptions to the hearsay exception. So I think the state has to bring it out because primacy and recency, right? You don't want to end the trial. You don't want the last, because this will be the last thing that the defense, if the prosecution doesn't bring it in, this will be the last thing that the defense will bring in, kind of as like a, kind of like a mic drop moment, right? So the prosecution has to bring it out. The only problem with them bringing it out is they'd be bringing it in under direct examination. They cannot ask leading questions. They cannot cross-examine, obviously, because they're bringing it out. But it would be, I think, if I was on the state side, I would definitely bring it out. But yeah, this is going to be helpful information for her, no doubt.